this is where a lot of misconceptions and violations of confidentiality occur. In no way, shape, or form do I want to denigrate well-meaning people who care and love for someone who's been harmed. But at the same time, there are assumptions made both by advocates as well as by family members and guardians and friends and others who feel like they, I won't say that they have the right to, but they want to know information because they care about a person. For example, in the realm that I work, people with disabilities, and being a family member of an individual with a disability, there's a presumption that, you know, as a child with a disability grows older and hits the age of 21, that the parent remains that individual's guardian. Au contraire. In order for someone to basically have access to another individual's information, confidential information, there has to be a legal mechanism in place that allows for that information to be shared. So, for example, one of those legal mechanisms can be guardianship. So individuals with certain types of disabilities or older adults who have cognitively related issues or have guardians, that guardianship, if it's spelled out in the guardianship itself, might allow for those guardians to have access to that information. For individuals who aren't under guardianship, but let's say that they have another tool of substitute decision-making, powers of attorney, whether it's power of attorney for health care, a power of attorney for finances. Again, it's that document that has been certified through the processes that vary in every state as to how you go about setting up legally that alternate substitute decision maker. That tool then would allow certain designated individuals to have access to the information. Family members, friends, sisters, neighbors, while they might want information because of a very benevolent reason, they're not allowed to have access to it. And as advocates, we have to be first and foremost respectful of the individual that we're working with. So, and their information, that includes their information. And so, for example, if I'm working with an older adult who says, you know, I really want my neighbor, Josephine, she's my best friend, she's my contact, I really want Josephine to be able to sit in with us on this conversation, or for you to call her and talk to her about what we discussed today, because if she knows she can help me remember, the two of us together can work on you know, ensuring my safety. That's possible. You just have to make sure that informed consent, that release of information, has been looked through, understood as far as what the potential consequences are for releasing information, and then if that victim makes that informed decision to sign that informed consent form, by all means, that's part of what you're doing. The bottom line for any substitute decision maker, whether it's a guardian, whether it's a power of attorney, or someone to whom a release has been issued with informed consent, it's always done at the direction of and hopefully with the individual who has that substitute decision maker. Why? It's their information. It's their life. And how you talk about their situation, it's important for them to know that what you're saying to a guardian, what you're saying to a power of attorney is the same as what you'd say to them. You're not talking about them in a disparaging, humiliating, disrespectful way. You're sharing exactly what that person wants you to share within the confines of what they've defined can be shared, and in a way that's respectful of their human dignity.